Yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred, to determine,
He's leaving.
He's walking.
He's leaving, right? It's like, here, let me come and mess with you more.
That would only...
Right? So it's like adding fuel to a fire.
Hello and welcome to the Southern Draw Law's Court of Public Opinion. I'm your host, James White. I'm a criminal defense attorney, former prosecutor, and former police officer. Today's case will take us back to Judge Fleischer's courtroom in Harris County, Texas, where he's going to be doing a probable cause determination on some sort of a disturbance call where the defendant is charged with interference with public duties. So without further ado, let's take a look at what Judge Fleischer has to say about this case.
Hi, good morning, Judge. My client is Michael Jones, and he's in custody, and he's asked me to argue probable cause for him, and so I
Sure,
shall.
of course. You ready?
Yes, Judge. Does he need to be brought out, or do you? I don't know your process.
Mr. Jones, please. Yeah. Good morning.
Hey,
How are you?
hey, buddy.
If you're banging on the door, you got to be careful because you break something, you're gonna catch another charge. So be careful banging on those windows because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not. Okay? Okay. What happened?
On January 10th, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas. The officer observed the defendant standing outside the location, being told to leave by the resident, to which the defendant refused by verbally yelling at the resident in a loud, aggressive tone of voice. The officer announced themselves and observed the defendant begin to walk away. The officer gave the defendant a verbal command to put his hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle and the defendant due to him pulling away. The officer began to roll around while on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted. Right?
So,
No.
Just losing?
So Judge Fleischer will do this from time to time. Are you losing? No, you're not losing, so shut up. People don't know what to say. Say nothing. That's the point. Don't start defending yourself unless you have a reason to defend yourself. The case is going your way. The judge is asking difficult questions. Just let it play out and see what happens.
So, Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location, being told to leave, and they observed him verbally refuse, and then...
Right, but then cops get up there.
And then they observed him begin to walk away, and it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and...
Didn't say that.
That was in the complete dims, Your Honor. And then it
Do you know about that?
Yes, Judge.
Behavior.
But
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance. Somebody's asking him to leave. They're yelling and screaming at each other. Police coming up and saying, "Hey, I'm the police." You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement, "I smell marijuana, you look intoxicated," because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs.
First of all, my favorite part of this whole thing is, I'm going to rewind it here and zoom in, is this cat's facial expressions while here's the lawyers laying that smackdown. It's hilarious, actually. So we'll zoom in here just so you guys can see. The defense lawyer here is mostly correct, but there's a couple misstatements of law. I don't think that the police had a lawful reason to hold this guy in the first place, but you actually don't have to be lawfully detained by police in order for the police to control your movements. In the state of Texas, there's actually a couple Fifth Circuit cases out there that suggest that the police can just tell you to back up, but they do have to have the lawful authority to control the thing they're trying to control. In order to be giving you a lawful order, they have to be in their official capacity doing a thing that they have authority to do. And actually, the authority to control is the most important consideration in this particular case, because what they've charged this gentleman with is interference with public duties, which is Texas Penal Code 38.15. So let's pull that up real quick and we'll take a look at it and kind of walk through it. A person commits an offense if the person with criminal negligence interrupts, disrupts, impedes, or otherwise interferes with, and he's charged under subsection 1, which is a peace officer, while the peace officer is performing a duty or exercising authority imposed or granted by law. So keep in mind, the operative part of this clause is performing a duty or exercising an authority imposed or granted by law. Well, then we need to know why you're stopping him in the first place. And so as applied to him, she's correct. They really don't have a right to control his movements at this point. But in general, there are circumstances where the police can control a person's movements without actually having them lawfully detained.
Walking away when a resident tells you to leave and all you've got in your sworn statement is, we identified ourselves as police. So what? Everything that happens after that is fruit of the poisonous tree.
So they go up and they see that he possibly could be intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, I'm the police, stop. We don't live in that kind of society. I'm the police, I need to investigate you, so therefore stop all day long. I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter all day long. But hey, I'm the popo.
I'm not corner, but this is another misstatement of the law. The police don't have to tell you why they stop you. I mean, it's nice, and it might be a policy concern for why a person needs to know, but there's actually no case law that suggests, other than like California and maybe a couple other places, certainly not in Texas as far as I know, where the police have to actually tell you that they're investigating you or why they're investigating you or give you a reason why you're detained. They have to have a lawful reason, but that articulation comes to the court at a later date. It doesn't come to the person on the scene.
So the reasonable suspicion we have is they begin to investigate what?
So
A criminal trespass.
they're called, yes, a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw.
So
signs.
the trespass investigation ceases because he's leaving.
Right.
Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is? The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to.
Yes. Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if trespass even occurred, to determine,
He's leaving.
he's walking.
He's leaving, right? It's like, here, let me come and mess with you more,
That would only.
right? So it's like adding fuel to a fire.
In this particular case, the judge is right. And what they're actually trying to investigate is a trespass. If you're stopping him for trespass, but you've observed him leave after the trespass warning, then you don't have reasonable articulable suspicion of a crime, because the crime is committed only by him remaining on the property after being told to leave. And so that can't be the crime. And so what else are you investigating? A lot of times you can learn a lot about what is not present and what actually is being said by the police. If you look at what they actually do, they continue to follow this guy, and then they sort of try to undertake an investigation into public intoxication. Well, if they felt like they had legal footing to originally detain him, why would they be searching for more stuff? They're taking the sort of kitchen sink approach and hoping they'll throw everything against the wall and stick with whatever sticks. But the truth of the matter is that if they had a reasonable grounds to detain him under the trespass or a disturbance or any other crime, well, they wouldn't be grasping at straws to try to figure out whether or not he was publicly intoxicated. And you have to keep in mind, too, that under most state statutes, public intoxication is not for being drunk in public. It's being drunk in public to the extent that you're doing something else. So it's usually a conjunctive test. And in Texas, it's drunk to the point to where you're a danger to yourself or someone else. Well, that's clearly not the case here. Nobody's making that argument. And so, again, of them having a lawful authority to give orders because they're detaining or whatever it is, and they have reasonable articulable suspicion that criminal activity is afoot, they don't actually have a right to hold this guy. So by virtue of him walking away, he's actually in complying with the trespass.
But they still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to miss one.
Well, they're going up to investigate what they saw, him refusing to leave, and
He leaves.
he only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't undercut their ability to investigate what they had observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
So I usually give Alex a little bit of grace here because if you've watched very much of Judge Fleischer's courtroom, you probably know that Alex is a third-year law student. He's not an actual lawyer. He's practicing under a limited license where he has to be supervised by a lawyer that's been practicing for a certain period of time. And most states have some rules where a third-year law student can act with some agency like the district attorney's office or the public defender's office, and they can actually practice and do what Alex is doing. And so I generally give him a little bit of a pass. But if he actually will take time later to listen to his argument, he's saying that the person walking away doesn't undercut the right of the police officer to investigate. That's true. The police officer does have the authority to investigate, but he has to have reasonable articulable suspicion that a criminal activity being afoot before you can detain a person.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know it was a trespass, it was a disturbance. We don't always specify the disturbance.
I'm going to find no probable cause.
You understand?
Mr. Jones, be careful, man.
So if I was going to render a verdict in this case, I would say that I would land exactly where Judge Fleischer's landed, which is that I don't think there's probable cause here. I think that you needed reasonable articulable suspicion in order to do an investigatory detention. I believe the crime they were investigating was trespass, and I believe the elements of criminal trespass were nullified when he made the decision to walk away. I believe what you actually have here is a contempt of cop. And that's, at least for now, not an actual charge. Anyway, that's all for this case. I really appreciate each and every one of you who took time to watch the video. I hope you got something from it. Please remember to like and subscribe. It really helps us with the YouTube algorithm. And I'm curious what your verdict would be, so leave it in the comments. If you enjoyed this video and you'd like to watch another one, I'll leave one in the end card for you to check out. With that, I'll sign off, and we'll see you on the next case.